Many states, a majority of states, have what's typically known as a Seat Belt Gag Rule. If the plaintiff was not wearing his or her seat belt, juries typically don't get to learn that fact. The defendant can't present evidence of seat belt non-use. And what that means is, if you have a collision where the plaintiff would have walked away maybe with a bruise had they been wearing their seat belt, but they weren't wearing their seat belt, so instead they've incurred some pretty serious injuries. The jury doesn't get to learn that the plaintiff, him or herself, was negligent for not wearing their seatbelt and could have avoided these injuries by doing what the law obligates them to do, wear their seatbelt when they're driving.
Why are we asking jurors to deliberate on incomplete information? We are asking them to do one of the toughest things, and that is listen to all these facts in a trial and go back into a room and deliberate and make a decision that is impactful to the plaintiff and to the defendant. And why would we ask them to take on that decision with incomplete information? They need all the information they can get in order to do their job and render something that is fair and just.
These rules are a relic of an earlier era, back in the 80s, when seatbelt mandatory use laws started going on the books in various states. There was still widespread opposition to seatbelt use, and a lot of people didn't think that they benefited safety, or even in some cases thought that they were a danger to occupants. And so legislatures that were adding these mandatory use laws in response to federal incentives wanted to minimize the consequences of non-use to their citizens. But that was 40 plus years ago, and things have changed in the interim, and everybody today recognizes that seatbelt use is very important for safety, that seatbelts are a good thing. They are mandatory nearly everywhere in the country, and they are very widely embraced. The vast majority of the country uses seatbelts every time they get in a car. So what do plaintiffs' lawyers say today when there's a proposal to repeal a seatbelt gag rule? Mostly a lot of hand-waving about prejudice to juries. If juries hear about a motorist not wearing their seatbelt, they'll be prejudiced against that plaintiff. It's a peculiar argument, really, because not wearing your seatbelt is relevant to the questions the jury has to answer about who was responsible for what kinds of injuries in the case. There's nothing prejudicial about the jury having that information. It's a crucial part of the case, just like every other piece of relevant evidence in the case has to figure into what the jury looks at when it decides why did this injury occur, whose unreasonable conduct led to the injury.
To be honest, the jurors are making up their own story in deliberation. They're discussing, hey, was the plaintiff wearing a seatbelt? If they had worn the seatbelt, maybe the injury wouldn't have been as bad. And they're having those conversations, and they're making up their own story based on their own personal experiences. Perhaps they were in a car accident and they didn't wear their seatbelt. And those personal experiences come into play. So again, if they're going to make up a story about it, why not let them have that information? Why not let them have the truth to begin with?